So good evening, everyone. Thank you for your punctuality. Thank you for connecting. Thank you for joining us for yet another edition of today's training. We appreciate your dedication. We appreciate your commitment to always connect to this meeting. Um, for those of you that are yet to get your link for your certificate, that's the serial number. Just be patient. You'll get your own soon. So don't worry. Don't be stopped. You receive your link possibly today. There is a link. Uh, Continue to send that number. Don't worry. You get of download your certificate as much as possible. But I hope the process of downloading the certificate is very simple. We did a video on how you can download a certificate. Maybe we'll share it as well, so that those who are not conversant with it can still look into it and then understand the process. So thank you very much for taking time to be part of this training as well. And thanks to those of you who are making effort to contribute to your impact. I've seen Dr. Emeka Odipo has been writing things since after his induction. He has been writing a lot of things on there, and so we appreciate you for the good work you are doing. We are impressed with what you are doing, and we say you should keep it up. Uh, just impact your society as much as you can. Do everything within your power to just impact your society and your community as much as you can. And that's what you're doing. I want to encourage you to keep it up. So far as your strength will take you, just go ahead and do it. So if you connect to this training, do well to share it with someone. I notice that people are not sharing as expected, but we expect that many of you should share as much as possible with someone, inviting them to take a free course with us and then be, engaged actively for what we are doing here. So today we are going to look at conciliation. Today we are going to look at conciliation. So we'll look at conciliation. We'll try to also look at the difference between conciliation and mediation. Do you understand? So do they have any differences? Are there any similarities? Are there differences? So you get to know when we start, all right? All of you for take part of it. Power from India. We appreciate you all the way from India. We appreciate you. I'm going to send you the serial number. You get your. I'm talking about Prashan Power. We're going to send you your serial number. You get your certificate today. All right. So don't be worried. You'll get it. Thank you very much joining us all the way from India, and we appreciate it. Thank you very much. So today we're going to look at conciliation, right? And we'll be looking at what the definition of conciliation. We'll be looking at the differences between conciliation and arbitration as well as negotiation. We'll look at the role of conciliation, all right, in dispute resolution. We'll also look at uh, some of the things that has to do with conciliation. So that we have an in-depth knowledge of what it's all about. All right. So, like I say, we are grouping you for our simulation or case studies or role playing um, kind of. It's going to be a kind of a test. so that you can come and demonstrate what you have learned in alternative dispute resolution here. So our focus is going to be on mediation, negotiation, arbitration, and possibly conciliation, and possibly conflict resolution. These five aspects, we are going to focus this simulation or role playing on this. And I'm going to group you into six. That is a group of six. Do you understand? Group A will contain six people. All right. Each group will contain six people. Um, Two people will serve as party A and party B. That is two each, party A and party B. And then two people may serve as facilitators, mediators, or arbitrators, or conciliators, as the case may be. Do you understand? So, and then we will do what we want to do. So we are going to send you topics as we assign the groups. We are going to send you topics. So we're grouping group A or group 1, 2, 2, or 2, the number of people that have applied or have indicated interest. So as many of you, but it's going to be 60 people. So let's see how it goes. And so once we group you, we'll drop the grouping in our WhatsApp group so that you can align yourselves and see how you can work together to perfect your distance. So your preparation. So try and be expectant as we are going to drop it very soon. All right. So I hope you are not forgetting what we learned yesterday on online dispute resolution. I hope you are not forgotten. And I hope some of you are going to participate to resolve dispute online in the course of your simulations or in course of role playing. You can settle cases online. So I just prepare your mind. It's going to be interesting time for that wonderful participation. We are starting on Thursday. So it means that we are grouping you today, tomorrow. We should assign you topics. At least you have Wednesday to prepare. Wednesday, or at least tomorrow and Wednesday to prepare. And then on Thursday, we will start the simulation. So just get yourself prepared to be part of it. So we are looking at conciliation. So what is the definition and the distinction of conciliation from mediation and arbitration? So we define conciliation as a process where a neutral third party, that is the conciliator, assists disputing parties in reaching a mutually satisfactory agreement. Now, let me just give you a quick difference between conciliation and mediation. In conciliation, the conciliator assists, but in mediation, the mediator only facilitates but does not assist. Do you understand? The only thing he can do is just to reframe issues based on the way the parties involved are discussing it, but just for the purpose of confirmation. But a conciliator can assist, even make suggestions. Do you understand? A conciliator can make suggestions where possible, but the parties have the final decision to whether go with the suggestion or not. Do you understand? That's it. So the conciliator may play a more proactive role compared to a mediator by suggesting solutions. That's what I was saying. Or proposing terms for settlement. Do you understand? He can even propose terms for settlement. He can suggest solutions based on the fact that he is a part of the process. He understands the concerns and so in the course of that, he can decide to make a suggestion. All right. So, but like I said, the parties involved may decide to take such suggestions or not. They may decide to take such proposals or not. Do you understand? So conciliation often focuses on what? Restoring relationship, and may involve more dialogue and negotiation. It may involve what? More dialogue and negotiation. So let's look at the distinction between conciliation and arbitration. Distinction between conciliation, arbitration, or rather the distinction among the three terms. When we talk about conciliation, mediation, and arbitration, do we have any differences? What are the distinctions? The distinctions may be in the role they play. So let's look at the role of the third party. The role of the third party. In conciliation, the conciliator actively engages in the discussions and may propose solutions to help the parties reach an agreement. That's what the conciliator does. But what about the mediator? The mediator facilitates communication but does not suggest specific solutions, right? Allowing the parties to create their own agreement. Allowing the parties to create their own agreement. Do you understand? So he is only facilitating, calling their attentions to issues, but he's not suggesting anything. He's not proposing any action. Do you understand? His own is just to facilitate the process and make sure that they discuss smoothly without misunderstanding, without any form of offenses. Do you understand? That is what the mediator does. But when it comes to the conciliator, what does the conciliator do? He makes suggestions. He proposes solutions. Do you understand? That's what he does. Then what about the arbitrator? The arbitrator makes a binding decision. That is, you can see the difference. Now, the facilitator can make suggestions, can propose solutions, but he is not imposing it on the participants to accept. The participants still have their right to choose from those suggestions or not. And then the mediator, on the other hand, does not at all make any suggestion. He only facilitates the process of conversation. But when it comes to arbitrator, he makes binding decision. That is, he imposes based on what he heard the parties discussed. He make a binding decisions. These are the difference. All right. So after hearing and seeing the evidences and arguments, he acts as a judge. The arbitrator acts as a judge. He makes a final decision that is binding on the parties. I hope you get the gist. You got the difference. I hope you got the difference because the difference is in the role they play. So we're talking about the role of the third party. That's number one difference. Number two, decision making authority. Decision making what? Authority. So in conciliation, outcomes are non-binding. The parties retain control over the final agreement, similar to mediation. Do you understand? So in conciliation as well, the conciliator does not have the authority to make a final and a binding decision on the parties. The parties still have total control of what becomes the outcomes of the negotiation or whatever issue they are working on. Do you understand? And then it has a similar aspect here with the mediation because even in the mediation, the mediator does not have a binding decision on the parties. And of course, it doesn't even make suggestions. The parties involved have total control of the process. It's just that in conciliation, the conciliator may, to some certain extent, influence the process, make suggestions. Do you understand? But the mediator doesn't do that. So, and what about arbitration? Results in a binding decision that the parties must follow. Decisions are binding. the arbitrator make the decisions, and the decisions are binding, and they are comparing for the parties to follow. Do you understand? So that's what it is. So when it comes to decision making authority in conciliation and mediation, the parties still have total control over decision making, the parties involved in the situation. But when it comes to arbitration, the parties have no such right. The arbitrator makes final and binding decisions. Are we together? So let's look at formality procedures. Let's look at the formalities and the procedures. When it comes to formalities and procedures, what is obtainable in conciliation, what is obtainable in mediation, and what is obtainable in arbitration. So when it comes to formality and procedures, in conciliation, it is less formal than arbitration and may be somewhat more structured than mediation. Do you understand? It will be more structured than mediation, but it's less formal than what arbitration. Because like in mediation, is unstructured. Mediation is totally unstructured. Do you understand? It doesn't have a formal structure, it's quite loose. Do you understand? So depending on the context anyway, but conciliations are more structured than mediation, depending on the context. Then in mediation, typically informal, emphasizing open dialogue and collaboration. You understand? They are unstructured and less formal. Do you understand? And then arbitration follows formal procedures. Arbitration follows what? Formal procedures and rules, resembling court processes. Resembling what? Court processes. So when it comes to arbitration, the procedure is very, very formal. And I think we have discussed that before. All right, when you want to use arbitration to settle your matter, what do? You initiate and then you send a request for arbitration. Do you understand? And all of those process, we have explained them in the time past. So just go and go through them again and refresh your memory. So when it comes to formality and procedures, both mediation and conciliation are less formal. And whereas conciliation more structured than mediation, but less formal when compared to arbitration. So that's how they differs when it comes to formality and procedures. So we have discussed in three ways in which arbitration, conciliation, and mediation differs. We talk about the role of the third party. We talk about the decision-making authority. We talk about the formality and the procedures. I hope we're together. So let's look at the outcome. The outcome. So in conciliation, outcomes, how do they come? Conciliation aims for a resolution that is acceptable to both parties with a focus on relationship building. Also, mediation also All right, thank you for joining. Still, thank you for maintaining your ground to wait for us to restore the network issues. But thank God we are back. And so we are discussing the differences among conciliation and arbitration. So we are looking at, and I was trying to recap when we went off. I said that we have seen three areas where mediation, conciliation, and arbitration differs. We look at the role of the third party, we look at the decision-making authority, and we are looking at the we look at the formality and the procedure. So we are looking also look at the outcomes. All right, I think that's where we're looking at the outcomes. All right, so the outcome, we say that conciliation aims for a resolution that is acceptable to both parties. Mediation also has such, right? But it doesn't focus on any form of intervention. If there's any issue, there's no much intervention. Do you understand? Unlike the conciliator may intervene and even make suggestions and make proposals. Do you understand? Then arbitration results in a win-lose on the arbitrator's decision. So you can imagine now, conciliation, mediation produce a result that aims to benefit what both parties. But arbitration aims to do what? Produce a winner and a loser. You understand? Result in a win-lose what situation. Just because the arbitrator make final decisions, and you don't expect that final decision to favor both. But it's possible that he can also make decisions that may favor both, but it's in rare situations. You understand? Rare situations. Confidentiality. Confidentiality. Always can be confidential, but conciliation and mediation are generally safe space for open discussion. Do you understand? So all of them can be confidential. All of them emphasize confidentiality. All right. So that is one area that all of them have similarities. All right. They all emphasize what? Confidentiality, secrecy. Then process dynamics. Process some may have a more advisory role, potentially providing expertise or recommendations, right, based on their what understanding of the issues at the hand. This can help clarify the situation and guide the parties towards a resolution. So that's what a conciliator does. Provide what advisory role, right? Advise, and then by his expertise and experiences, guide and make suggestions. But in mediation, the mediator focuses on facilitating communication and helping parties identify their interests and needs, facilitate work communications. So the mediator encourages them to explore options without providing specific guidance on the outcome. You understand? So let's discuss this in an understandable manner without shouting. Do you understand? This is a mediator for you. Trying to calm them down and all of that, just to find a common way to discuss and make sure that they find a resolution for themselves. And then arbitration, the arbitrator controls the process. The arbitrator controls the process, setting timelines, rules of evidence, and the overall framework for the proceedings. This structure can make arbitration more predictable but less flexible. more predictable. It's possible you may foresee the outcome. You understand? It's possible based on the evidence submitted and based on the language of the arbitrator. It may it may give you an insight on how the outcome of the arbitration process may be. Do you understand? So that's what it is. Let's look at focus on relationship. Conciliation often emphasizes repairing and maintaining the relationship between parties, making it suitable for dispute where ongoing interaction is important. So conciliation often emphasizes repairing and maintaining relationships. Do you understand? Because it's not just about settling dispute, but also trying to unite the people involved in the dispute. You understand? That's the role of a conciliator. So come and settle dispute and go. But you also unite the people that are involved in dispute. Do you understand? So we have, and that's why we have a place of reconciliation, conciliation, reconciliation. Do you understand? So now mediation. Why also relationship focused? Mediation may prioritize problem solving over relationship dynamics, depending on the party's goal. If the goal of the party is to preserve relationship, mediation can as well help. Otherwise, let's try and settle the problem. It's the problem that we need to deal with, not the relationship. Do you understand? So that is what uh, uh, that's what the focus on solving problems, not on repairing the maintenance of relationship, but the goals of the participant may determine what happens because they are the ones that have total control of the process. So if they say maintaining the relationship is a key to them, because there are situations whereby you want to solve a problem. Take for instance now the problem between husband and wife. All of them are not interested in divorce. Do you understand? So whatever that we are doing to solve this problem, it must be resolved in such a way that the marriage continues. Do you understand? Very important. Or a business partner, you are not willing to disassociate. You want to just resolve problem and still continue to do business together. Do you understand? So such is important. So, but the goal of the parties may determine if a party so wish and say, I don't want to continue with this relationship. All I want is let's solve this problem. I don't care what happened with the relationship. Anybody can go his own way. I don't care. There are some people that speak like that. So it clearly shows that they are not interested in maintaining that relationship. All they want is let this problem be resolved. And whatever happened after is none of my business. I don't care about it. Whether he wants to continue with the relationship or he doesn't want to continue with the relationship, I don't care. That's how people talk. Most especially when they have given up on their relationship. Do you understand? Once they have given up on their relationship, they can make this kind of comment and forget about it. Are we together? So flexibility, flexibility. So okay, I have not talked about arbitration. So arbitration typically less concerned with relationship and it is more about resolving the legal aspect of a dispute. The legal aspect of a dispute. Do you understand? Because we told you that arbitration focuses more on what is enforceable, right? So the law is so much emphasized here. So once the decision is made, the relationship between the parties may not be primary a consideration. It may not be a primary consideration. So flexibility, conciliation offers high flexibility in terms of process and outcomes. Parties can explore a wide range of solutions beyond legal remedies. But mediation, on the other hand, is also flexible, allowing parties to craft solutions that best meet their what needs and interests. But when it comes to arbitration, it's less what flexible. The parties don't have any control, the arbitrator are in charge and of course make binding decisions. So if they say meeting is by 10, you should be there by 10 or before 10. It's not something that you come and be saying, give me another opportunity. I have something that have to keep me also. I will not be able to come. Oh, this one or this one. Oh, let us do it online since I cannot make it physical. But it was supposed to be a physical meeting. In arbitration, you will not have that privilege. But in mediation, it's possible that well, if you cannot come, let's do it online. Let's just connect on whatever platform available. Let's do it. Do you understand? That's how flexible mediation and conciliation may be. But when it comes to arbitration, no, no. If it's going to be a physical event or meeting, you must be there physically. Otherwise, you receive penalty. All right. So legal context. Legal context. Conciliation sometimes used in specific contexts such as labor disputes, where parties may seek a more collaborative process. It may also occur before formal legal proceedings. Mediation widely used across various contexts, including family disputes, commercial disagreement, and community conflict, often as a first step before litigation. That is, you can use mediation effort, you can put in effort to mediate and see that you can get result. But if you do not get result, you can proceed and go to court, as the case may be. Arbitration commonly found in commercial contracts and international disputes where parties agreed in advance to resolve their issues through arbitration rather than going to court. Do you understand? So we have told you you can sign a contract and then you say you are going to use in case of any misunderstanding or disagreement. Instead of going to court, you for agreed that if in case in the course of our interaction, in course of business transactions, we have differences, we are not going to court. We are going to use arbitration. You for agreed already. You have agreed before time that you are not going to go to court. All right. So cost and time efficiency. Conciliation generally designed to be cost effective and quicker than litigation, as the focus is on reaching what an agreement without lengthy procedures. Mediation similarly aims to be efficient and less costly than court proceedings with the potential for a faster resolution. Do you understand? But when it comes to arbitration, what happens? It's often faster than litigation, but it can still incur significant costs due to formal procedures, expert witnesses, and fees for the arbitrators. And at the same time, you have to also take it to court for what? Enforcement. So it consumes time more than the other ones that we have talked about. But it's also quite efficient in terms of the cost. Cultural context. Cultural context. Conciliation may be more prevalent in cultures or industries that value consensus and collaborative problem solving, such as in some Asian or indigenous cultures. All right. Then we have mediation used across various cultures, but may be adapted to fit local customs and norms regarding conflict resolutions. So what is obtainable in your place, you can use traditional way of resolving conflict, mediating. Do you understand? When there's an issue in your community, sometimes they expect that the elders should mediate. So they can mediate, you can be a facilitator. You understand? They can talk, they can discuss, you can facilitate. So you can facilitate a process of negotiation using traditional method of handling issues. You quote what their tradition says. Do you understand? So that's what it means. When you are mediating, it's possible that you can come to a community and you want to know what the community says concerning matters like this. So when the parties are discussing, you hold their attention. See, this is what your community says. Do you understand? That is mediation. This is what your customs say it should be done. So arbitration often favors in business and international context where parties seek a neutral formal process governed by the you know by the established rules, which we have mentioned them, the established rules like ICC or the UNCINTRA or the London International Court of Arbitration. All of those are there. So these are the ways in which arbitration, mediation, and conciliation differs. So now at least you can be able to point out the differences between the two and possibly similarities. Do you understand? Are there any similarities? Most especially, conciliation and mediation have a lot of similarities. It's arbitration that is standing on its own, it's being offside. Do you understand? Consistently. On all aspects, arbitration seems to be uh, quite dynamic. It's just in one area that they try to have similarity, which is confidentiality. Otherwise, in all other aspects, arbitration seems to be more offside. Do you understand? So let's look at the role of the conciliator in dispute resolution process. What is the role of the conciliator in dispute resolution process? Like I say, we are going to give you topics. They may be bordered on conciliation, arbitration, negotiation, mediations, and conflict resolutions. These are the areas we are going to give you topics for simulations, role playing, and maybe case studies, as the case may be. We give you a case study scenario for you to, you know, deal with. So just prepare yourself. So we're talking about conciliation. So look at the role of a conciliator in dispute resolution process. So you should pay attention so that you understand. So in case if you have a topic that has to do with conciliation and the role of a conciliator, then you shouldn't be confused. All right. So key role of the conciliator is neutral facilitator. Neutral what? Facilitator. The conciliator acts as an impartial third party, ensuring that all parties feel heard and respected throughout the process. Right? This neutrality helps build trust and encourages open communication. The conciliator acts as what? An impartial third party, ensuring that all parties feel heard and respected throughout the process. So, even though we say that a conciliator can make suggestions and propose solutions, it does not mean that it's going to be partial. He remains as neutral as possible to make sure that whatever proposal he's making, whatever suggestion he's making, is going to be for the benefit of all the parties involved. Do you understand? So he is not to take side or show any interest on the matter. So far as the matter is concerned, it's not his. So he's not to show interest in the matter in whatever aspect of the matter. But he can make suggestions, he can propose solution terms and all of that. So that is one of the roles. So as a neutral facilitator, you can make suggestions, you can propose terms of solutions, but you are not to take side. Neutrality is one of the guiding principles in conciliation. Then encouraging dialogue. A conciliator facilitates what discussions between disputing parties, helping them express their concerns, interests, and viewpoints. This dialogue can clarify understanding, or foster a collaboration of atmosphere. Do you understand? So that's what it is. They facilitate discussions, they guide. That is, there are some basic principles that may guide the facilitation. No insult, no abuse, no shouting, maintain your normal tune. Do you understand? And engage. You are not to be operating from while we are discussing. So, in case you want to deviate, the conciliator may call your attention to it. Do you understand? So, he encouraged dialogue. That is, people discuss their problem and he helped them in the process. Identifying interests, right? Identifying interests. The conciliator assists parties in identifying their underlying interests and needs rather than just their position. So because there may be some needs, but maybe the parties are not seeing it. So your job as a conciliator is to call their attention to those needs. Do you understand? It seems that people have a need here and there. Oh, is it me that I'm seeing something different? I hope this is what people are trying to arrive at. I think this is your interest in this. You understand? So you get their attention to know that okay, this is what they want and this is what they're referring to. So rather than their position they maintain that okay, this is what I want. No, what you want may be different from what you need. So call your attention to see the need and not just what you want. All right. So by focusing on interests, parties can explore more creative and satisfactory solutions altogether. So proposing solutions. Unlike mediators, conciliators may actively suggest solutions or terms for settlement based on their understanding of the issue. So once you have heard and have sufficient information, you can make authoritative suggestions, suggestions that are influencing, that can influence the behavior and the decisions of the parties involved. So these proposals can help parties see potential pathways to resolution they might not have considered. So you have maybe the issue they are discussing, you have you know an in-depth in the issues, you have deep insight on the matter. So you can make suggestions and call their attention to issues they may not ordinarily see it. Managing emotions. So conflict often involves strong emotions, of course. So the job of the conciliator is to do what helps manage these emotions by maintaining a calm and constructive environment, which is essential to effective work communication. So when somebody wants to raise the voice up, you say, no, 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 calm down, calm down. Let's discuss it. Calm down, calm down. You understand? Calm all the way down. Let's discuss it. It's not a matter of shouting. Calm down. Lower your voice. I know it's painful. I know that you are provoked, but calm down. Let's discuss it. Do you understand? That's your job. Manage emotions. All right. Manage emotions. Clarifying issues. So the conciliator can help clarify complex issues or misconceptions that may be contributing to the dispute. This clarification can lead to a better understanding of the situation and facilitate resolution. Because there are some issues that may be ambiguous, there are some issues that may not find the right expressions. Do you understand? So it's the job of the facilitator to help the parties involved to understand it clearly. Do you understand? To have a wider understanding of the issue in perspective. So once they are able to do that, they'll be able to have a solution. So building relationships. A key objectives of conciliation is to restore or maintain relationship between the parties. So the conciliator works to foster a collaborative spirit, which is especially important in dispute resolution. All right. So most especially conflict that has to do with family issues or workplace settings, the all the tendency and the intention is to build and restore relationship. You understand? Because these people can continue to work together. They can continue to exist or coexist together. They co-live together. You understand? So if it's a family matter, you must aim at building relationship. If the matter of colleagues working in the organization, you must work to make sure that this relationship is maintained for productivity, because it's possible that conflict may be going on in organization and that affects team spirit and also teamwork, and of course it affects the productivity of that organization. So you must work to restore relationship, and that's the job of a conciliator, building relationships. Creating a safe environment, make an environment so confidential, make it so safe for somebody to express his or her mind without any form of prejudice, without any form of victimization. Everybody is free to express themselves as they like. Do you understand? So without abusing anybody, without insulting anybody, just express yourself in a respectful manner. All right, and that is trustworthy, that is confidential. Do you understand? That's why it is. Create a safe environment. Flexibility in process. Flexibility in process. Right. So make the process to be as flexible as possible. Right. So that the needs of the parties involved can be, you know, uh, adapt. You know, they can adapt to their needs as much as possible. So this first flexibility may involve adjusting the format of discussion, the location, or the pacing of the process. It may help them to deal with the situation. So summarizing agreement. So once an agreement is reached, the conciliator may help summarize the terms and ensure that all parties understand and agree to the terms. This documentation can serve as a reference for future interaction. So maybe at the end of it all, so we will reach an agreement. Oh, when are we writing our exams? Oh, the first Saturday after training, we'll write our exams. Agree? Yes, agree. So we'll take note. Hmm? Oh, what time are we writing our exams? And we're writing our exams by 7 a.m. Agree? Agreed. We take note. Do you understand? So at the end of the discussion, I may take to summarize that we have agreed that we're going to write our examination first Saturday after what training. Is that what we agreed? You people will say it in affirmation that yes, that's what we agreed. And that you people say we are going to write our exam by 7 a.m., right? Yes, 7 a.m. That's what we agreed. Do you understand? So you guys agreement. So then you follow up. In some cases, the conciliator may offer follow-up sessions to ensure that the agreed upon terms are being implemented and to address any new issues that may arise. Do you understand? So that's what the conciliator does. So follow up to make sure that the agreed terms are being applied or are being applied. It's very important. All right. So I hope we are making progress, and I hope you are understanding me. And I hope you have shared the meeting with someone to be part of what we are doing here. Share it with someone, invite them to be part of it. Put the link on your wall, just share it on your wall, invite them to come and be part of it. That's what we're saying. And of course, you can like and you can also comment. Let's know what's going on. So we are going to look at the last topic for tonight, which is techniques used in conciliation to promote settlement. Techniques used in conciliation to promote settlement. What are those techniques used in conciliation to promote settlement? So we have a several number of those techniques, all right? We'll be discussing them here. So we say enhancing group decision making and consensus building involves employing various techniques that foster collaboration, communication, and mutual understanding among participants. So some of the techniques that enhance group discussion or group decision making includes structured brainstorming. Structured what? Brainstorming. So encourage all groups members to contribute ideas without judgment. So someone can give us, no matter how foolish you think someone's idea is, don't criticize the person. Do you understand? No matter how useless you think the idea is, don't criticize the person. So what do? Use techniques like round what robin. What that means, just rub our minds, right? That's kind of rubbing our minds, right? To ensure everyone has a chance to speak. So you speak, right? After you finish, another person speak. When you finish, another person. So round robin. So everybody must speak. Do you understand? So we rub our minds, and then this promotes creativity and inclusivity. It gives a sense of belonging. Do you understand? So everybody knows that okay, at least that feeling of satisfaction of being given opportunity to participate, right? It's there. So I participated as well. Do you understand? So it gives satisfaction. That's number one. Number two, nominal group techniques. Nominal group techniques. Do you know what this technique is? Each member writes down their ideas independently, then shares them with the group. Then the group discusses and ranks the ideas, allowing for a systemic approach to decision making. All right. So once you rank you, that's you can rate the ideas and prioritize them. Do you understand? So and of course, those ones that address high priorities may be the ones that may be considered at the end of the day. Because every organization have their top priorities. So if a top priority is involved in your idea, that may be considered before any other ideas. Do you understand? Some other ideas may just be added to make your idea more stronger. Then we'll talk about daily techniques. The daily techniques gather input from group members, all right, anonymously through surveys or questionnaires. Nobody asks, answer and write their names. Everybody answers questionnaires or surveys normally. Do you understand? Without inputting their details. After several rounds of feedback, the group can converge on a consensus without direct confrontation. Without direct confrontation, because you don't know who answered what. So you just see an answer based on the questions provided. Do you understand? So you may not know who says it. So there's no need for confrontation. So, but you just sit and look at it as a group and decide based of the ideas that are involved. That's the daily techniques. This helps to, you know, deal with the issue of animosity. Do you understand? So there's no element of hatred and malice keeping, and because when it was there, you were ignoring my idea. I give great idea. You are always attacking me. You are always attacking me. Everybody give their idea. You didn't say anything, but once it was my own, you just stood up and rebuked me like, I don't know why you're always attacking me. And I'm warning you, one day I will show you shege. I will deal with you. You will not forget me. So that, there is no such kind of confrontation here. Why? Why? Because the techniques hide the identity of the respondent. Do you understand? You responded to a questionnaire, but your identity is not revealed. So there's no room for confrontation. So the daily techniques can help you to deal with that issues. Then multi-voting. Multi-voting. Use a voting system where each participant can vote on their preferred options. This helps prioritize ideas and identify the most favored choices among the group. So in case whereby agreement cannot be reached, let's vote. That's why even in the House of the Senate, the House of Reps, or in assembly members, you see people voting. Those who say aye, those who say nay, so the aye have it. The ayes are always having it, so they have it. So, but here it's not just those who say aye. Here, raise up your hand. We will count. Okay, we'll count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Go for this particular idea. Second idea, how many people? 1, 2, 3, 4. Okay, only 4 people. So you know that, okay, this technique, this particular idea is not comparable to the first one. Do you understand? So you go with the first one. Multi-voting. Facilitated discussions. Employ a neutral facilitator to guide discussions, manage conflicts, and ensure that all voices are heard. A facilitator can help maintain focus and structure. All right. So that is it. Then we look at SWOT analysis. SWOT what? SWOT analysis. You know what SWOT analysis means, right? So you're going to analyze the strengths, the weaknesses, the opportunities, and the threats related to decision. So this structure analysis can help clarify options and guide the decision-making process. Now, when you have an option or an idea, then you are going to put this an idea and examine it, analyze it based on its what strength, based on its what weaknesses, based on its what opportunities, and based on the threats or the risk involved. So you are going to analyze this idea. Okay, we say okay, for instance now, we say okay, the idea is okay, let's take maybe for instance 2 ideas to have this training that we are doing physically and then to have it online. Do you understand? Let's say we want to have this training online or let's have it physically. So let's analyze the situation based on the strengths, based on weaknesses, based on opportunities, and based on threats. Can we analyze this? Right? When we're talking about the strength of it, is that if we say this meeting should be physical, then we will have less participants and we'll reach out to less people. But if it's online, many people will have opportunity to participate. And then we'll look at, okay, on the strength of safety, then we'll say that online facilitation may give us more security than traveling on roads where we may have road accident or fall victim of kidnapping and all of that. This you are analyzing the ideas. Do you understand the idea of either physical training or online training? So we are looking at the strength of each. Do you understand? So if we say we'll do it online, then our security may be guaranteed. But if it's physical, our security may be risked because I'm going to travel from Lagos. So the possibility of having road accident is there, the possibility of being kidnapped, the possibility of being robbed, and other possibilities, or even the distance cover, health challenges, and all of that are involved. You understand? So you are weighing the weaknesses and the strength of this. All right. And then of course you are weighing the weaknesses of also online. connections, maybe network issues, network frustrations, lack of good devices to connect, and things like that may also be. So, what are opportunities? You understand? If it's physical, there's possibility of networking, connecting with one another, making friends. Or if it's online, is there any opportunity we will discuss? Mhm. So, but even online, we have a way we can meet. You understand? We have groups. We have. We are also going to have peace clinic where people may be compared to work together to connect. You understand? So, there are such opportunities, and maybe in that, by doing so, they may introduce themselves and what they are doing. You understand where they come from. So there's that opportunity to connect. We have Prashant from India. Maybe he may be in a group, and somebody in that group may want to go and visit India. Do you understand? And maybe they were in the same group, and then you will call Prashant, please, I have a business trip to make to India. Um, can you be available to put me through? We meet when we were doing training online or alternative dispute resolution. Or you can be in Kenya. You will meet Jen Wakesa. Do you understand? She's there. She can help you to put you through. Or you can be in Sierra Leone. You can be in Malawi. Can be it's people come to people. We have different people from Cameroon. They are here. Do you understand? So there's that possibility of connection. So all of this, you are going to weigh. We are going to weigh these ideas based on their strengths, weaknesses, opportunities, and threats. Do you understand? So these are the things. Of course, if you are going to visit India and you have not met Persian one on one before, you just met online here, then there is also the challenges of your security being guaranteed. Do you understand? So that may also be a source of concern. So these are the issues. So, but you are going to weigh. I'm just giving you an instance on how you are going to analyze these ideas based on these factors we have mentioned here: strength, weaknesses, opportunity, and threat. You understand? So you're going to consider, and then that will help you to make a sound decision. Consensus workshops. Consensus what? Workshop. Consensus workshop. So organized workshop focus on building consensus. Organized what? Workshop focuses on what? Building consensus. Use techniques like small group discussions to explore diverse perspectives before bringing insight back to the larger group. And that's why we're going to divide you for simulation. You come and practice. After you have discussed from your groups, you come and then we'll put you on live studio. You come and discuss with other larger audience who also connect to listen to you. Do you understand? So we're going to do things like this. So role rotation, role rotation. So rotate roles within the group, facilitators, note takers, to encourage diverse viewpoints and encourage equitable participation. So this approach helps members appreciate different perspectives. Do you understand? So that's a scenario planning, scenario word planning. That's what we're going to do for you. Scenario planning. Create and discuss hypothetical scenarios related to what decisions at hand. This encourages exploration of potential outcomes and help the group consider various angles. All right. So mind mapping. I'm talking about techniques that help you to make group decisions. You understand? Mind mapping. So use visual aids like mind maps to organize thoughts and ideas around a central theme. These techniques can help clarify relationship between ideas and foster creative thinking. So it also define pathways on how you are going to arrive at certain things. Do you understand? Mind mapping. Maybe some of you that did the project management or monitor and evaluation, you may understand what mind mapping is. But it defines pathways as well to how you reach to a particular destination and how other angles support uh, certain ideas support another central idea. So all of this you define them, right? Then let's look at techniques for consensus building. The ones we look at, the ones we just look at are techniques for group decision making. And let me just do a recap so that we can have a sound understanding. What are the techniques here? We have structured brainstorming, we have nominal group techniques, we have daily techniques, we have multi-voting, we have facilitated discussion, we have SWOT analysis, we have consensus workshops, role rotations, we have scenario planning, and we have mind mapping. So these are some of the techniques you can use. You can use any of these depending on the case you are trying to address. All right. So techniques for consensus building. Techniques for consensus building. So active listening. Active listening. So one of the ways you can be able to build consensus is to listen carefully and attentively. So listen without interrupting anybody. Summarizing what others have said, it shows a sign of what you listening ability. Some of you are paraphrasing what I'm saying here. Some of you are paraphrasing what I'm saying here. So it shows that you are listening to me constantly. So common ground identification. Identify areas of interest. Identify what areas of interest. Highlight those areas of interest. It can help to build what bridges where there are differences. Interest-based negotiation. Interest-based what negotiation? Encourage participants to express their underlying interests rather than their positions, because their position may be rigid. So encourage them to adjust and make adjustments and shift positions so that decisions can be made. Consensus cards. Consensus cards. Use colored cards like green for agreement, yellow for concerns, red for disagreement. Use what colored cards. Green for agreement, yellow for concerns. That is the matter, it's not yet clear. Red for disagreement, total disagreement. To gauge group sentiment on specific issues. So this visual representation can help clarify areas of consensus and dissent. Do you understand? Then collaborative problem solving. Collaborative problem solving. Frame discussions around collaborative solutions rather than adversarial debates. Don't bring a debate that creates enmity. Don't bring issues that or discussions that create animosity, that create hatred. Encourage participants to work together to find a win-win outcomes. All right. Don't make someone to be a winner and then another a loser. You make permanent enemies. Incremental decision making. Incremental decision making. Break complex decisions into smaller, manageable parts. Building consensus on smaller issues can lead to agreement on larger decisions. You understand? So make decision making easier for people by breaking issues down. All right. Break it down, break it down, break it down, break it down. All right. Feedback loops. Establish feedback mechanism for ongoing feedback through the decision making process. Regular check-ins can help adjust approaches and ensure continued buy-in. So these are some of the techniques you can use to build consensus. You understand? Feedback loops, incremental decision making, collaborative problem solving, consensus cars, interest-based negotiation, common grounds identification are active listening. Thank you very much for being part of today's training. We appreciate you for your dedication and your commitment. So, any query? So, for those of you that I say before you join, maybe you have not received your serial number to download your certificate on emotional intelligence. You will receive it by God's grace tonight. As much as my strength can carry me, I will send it as many as I can. But in case you are not able to receive tonight, you will still receive it tomorrow. So don't be afraid, don't panic. You're going to get your serial number to get your certificate. And we'll also share a video on how to download and save your certificate, maybe using a computer. We're trying to do the one that you can use your phone. Many of you are going to use your phones anyway, but we share the one. The process is almost similar anyway. So it will help you to download your certificate easily. So we'll share that video that will help you to get some of these details. So thank you very much. We appreciate you. And we thank you for also sharing this meeting with someone to be part of it. And so you both should be reading your books. Read the one I gave you. This one may also be ready by 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 Sunday. By Sunday also. So the next Saturday we'll be writing our exams. So just be reading. Try to revisit some of the videos we have, recorded, so that you can, remind yourselves of some of the explanations we explain in the process of delivering the classes. So, and then you combine that with your manual, and then it will give you more insight. Do you have any problem? Someone is saying that I was not able to download my certificate due to network failure in your area. So go to where there is no network failure, then you can download your certificate. It's as simple as that. Okonko Chena. If you say you have not gotten the material, it means that you're not in the alternative dispute resolution group. And if you are not there, it means that you are in the wrong place, because you're supposed to be in that group. It's only people that are registered for this training that are going to get certificate. So, and if you are registered for this training, a group link was provided for you to join. So if you're not in that group, try and be in that group. The manual is shared there. Or you go there and get the manual. So that is just it. The manual is already in the group. Go there and get your manual. And you're asking, is there any law guiding ADR in Nigeria? We have during when we're talking about uh, ADR, we're talking about arbitration also. We're talking about some of when we're talking about uh, AAA, that is American Association of what arbitration. Okay, we also talk about um, ACA in Nigeria, or Abi is it ACA also, Association of what something on arbitration. They also have something like that. We have some laws that govern arbitration process. It's just that we have not been fully practicing. Some of the judiciaries, some of the legal institution here, they have what we call the arbitration centers. We even have one. Some of the ministries, they have what we call arbitration centers. Do you understand? It's just that they are not being actively being used, but we have. Just make a research on it, you see. We have arbitration centers like in Bayelsa. I knew of our member, a member of the institute, who works in that center as well. You understand? So we have. So thank you very much for being part of today's training. See you tomorrow by 7 p.m. Have a wonderful night rest. Good night.